I've reviewed, negotiated, litigated, and argued thousands of contracts over 20 years of law and business. Here's what most entrepreneurs don't realize. Your contract is worth more than just your paycheck. And it's one of the biggest reasons why entrepreneurs fail. One mistake in your agreement and your business could be bleeding money in court while your competitor takes your clients, or even worse, your intellectual property and everything you worked so hard for. So in this video, I'm going to show you the 5 deadly contract mistakes that destroy businesses every day, and more importantly, how to legally bulletproof your agreements like a courtroom attorney. And that's what I used to be for nearly 20 years, right? Because when things go down, and they will, believe me, your contract is the only thing standing between you and a financial disaster, and you're gonna love me for the lesson you're gonna learn today. Let's start with something most entrepreneurs get completely wrong. They think contracts are just paperwork, something you sign and forget about it. They may not even bother using a contract, or they'll just download something off the internet for a couple of dollars. Now that's just completely backwards thinking. A contract isn't paperwork. It's your business's legal armor. It's the only thing you really have. It's your best friend. It's your strongest weapon if you know how to use it. It's enforceable protection that kicks in exactly when everything else falls apart. It's meant to give you power, influence, and leverage. That's what I do for clients. So learn them and learn how to use them and put them in writing. And yes, verbal contracts can be enforceable sometimes, but good luck proving what was actually said a year ago in court, sitting in front of a judge who's never met either of you, and doesn't care about your contract, doesn't care about your business, and wants you out of his courtroom. So here's the brutal reality. If you don't have a clear written contract, a judge decides your business fate based on vibes and faded memories, right? That's expensive, time-consuming, and completely unpredictable. And unpredictability is the enemy of a profitable business. So when I say your contract is worth more than your paycheck, I really mean it. So let's jump right into the 5 deadly contract mistakes that nearly all entrepreneurs make, and we gotta stop making them. The first mistake is the most obvious, right? But it's still happening every single day. Entrepreneurs are working without written contracts. But we shook hands on it, but we had emails discussing the project, but they seem trustworthy. I don't care what level of sophistication. I've seen it all, and I've had to go into court to try to argue, try to put together verbal agreements. Now, without a written contract, you're not litigating the terms of your agreement. You're litigating behavior. You're asking a judge to decide who's telling the truth about a conversation that happened months ago, and you're putting your business destiny in a judge's hands, right? And the judge hates that because the judge wasn't there. The judge doesn't know you. The judge doesn't know your client. They don't know your business. They don't really care. And guess what happens when a judge has to guess? They're gonna rule against you, the business owner, because business owners are supposed to know better. You're supposed to have your legal house in order. That's what the law says. And you're the one who's giving people contracts. So the judge thinks if this business owner was professional enough to run a company, why weren't they professional enough to get a written contract? That's how simple it is, right? It's not fair, but that's reality. Judges aren't business people. And the reality is they don't care about your feelings or your cash flow. They care about lunch and getting you out of their courtroom, and you won't hear that anywhere else. So do yourself a favor and have a good, clear contract that a judge can easily hang their hat on. Now, mistake number 2 is downloading some generic contract template from the internet and thinking you're protected, right? Here's the problem with most of these downloadable contracts. They're vague, they're incomplete, and they're definitely not specific to your industry or your business model or your business at all. These templates don't protect your scope of work. They don't protect your payment terms. They don't protect your deliverables or your IP. But here's the bigger problem. You have no relationship with whoever drafted that template. Are they even an attorney? Which matters enormously when you're operating a business. Do you know the attorney who drafted your contract? Do they have business and court experience? Most attorneys don't. Can they tell you how to modify the contract and give you advice on how to use the contract, explain them to you? Because most lawyers don't even know themselves. They don't do business. When I draft a contract for a client, I know their business, I know their industry, I know what disputes they're likely to face because I've handled those disputes before, and I have nearly 20 years of experience both as an attorney and as an entrepreneur under my belt who's actually been in court and tested contracts. But you use some lawyer who wrote a generic contract some 6 years ago who doesn't know you, they've never met you, they don't know your business model, they don't know what you need protection from. So you end up with a contract that looks official but provides really no legal protection. It's like wearing a bulletproof vest made out of cardboard. So it looks good until someone starts shooting at you. Now this brings us to mistake number 3, and that's not understanding the terms in your own contract. And nearly all entrepreneurs I've met don't really understand the contract that brought them to court, right? Some legal jargon doesn't equal protection, right? If you don't understand what it actually means. And here's the rule that will shock most entrepreneurs. Courts interpret contract ambiguities against you, against the drafter. That means if you gave your client a contract where there's unclear language, it's ambiguous, judge is going to interpret that against you. They're going to blame you. You're the business person. You're the one who should write the contract clearly. The client's going to win. I've seen all day long because courts assume that if you drafted the contract, you had the opportunity to make it clear. It's your burden. So if it's not clear, that's your fault. It's not theirs, especially when they look at consumers, they're in a lower position of power. And that's why you can't just copy and paste legal language you found online. If you don't understand what these words mean, and if they're not written specifically to your situation, you could be accidentally creating liability instead of protecting yourself. I've seen entrepreneurs lose cases, not because the client was right, but because they didn't have the right contract, the right terms, you name it. Even Mr. Beast this happened to. So now let's talk about mistake number 4, and that's missing the protective clauses that actually matter. Now, there's a lot of contract provisions that go into different contracts and you name it. But when it comes to client contracts, I'm talking about client contracts, you should watch my webinar about it. There's 6 critical protective elements you need in there, right? Number 1, you need a clear scope of work. And you need to exclude what's excluded. That's just as important as what's included, right? Number 2, you need to have change orders with additional fees in writing because clients will always want more than they paid for. Number 3, you have to detail ownership of intellectual property rights, who gets what, and what are the legal consequences. That's something that most entrepreneurs forget about, which is very basic. 4th, you need indemnification. This determines who pays the legal bills and the costs if someone sues you over your work, and that's very important. Leverage over the client. Number 5, and I see this now in the world of the internet, non-disparagement provisions. You need these against your client, protect you, to protect your reputation. You never know. And number 6, it's all about attorney fees, liquidated damages, certain punitive provisions that are meant to give you leverage and power to prevent going to court. So when you have an issue with a client, you can send them a letter and say, hey, we're not going to go to court because if we go to court, you got to pay my attorney fees, you got to pay my cost, we got indemnity, we got liquidated damages. So those are protective terms you need. And now this brings us to the 5th and final mistake, and this is the most important one. It's not having a trusted attorney in your corner, a business attorney. Someone who actually understands your business. Now, you don't need a lawyer just for contract drafting. You need a lawyer for strategy. Someone who understands your business and is a business person, and they can evolve your contracts as your business grows. Someone who can mentor you and teach you from the mistakes of others he's seen like you, because lawyers have seen so many problems over their career. Because here's what most entrepreneurs don't realize. Waiting until you're in litigation to hire legal counsel means you're now playing defense and you're going to lose. You're reacting to problems instead of preventing them, and you're now likely to have cancer that's metastasized. But when you have an ongoing relationship with an attorney who's your mentor, who knows your business, you're playing offense. You're preventing problems before they cost you money. You're being proactive. Your business evolves, your clients change, your services expand, your contract should evolve with you. Not stay frozen in time with some template you downloaded 3 years ago, because the law does change and it does all the time. And that's how you stay legally bulletproof. And you get the much needed protection, certainty, and support that entrepreneurs need to win. And those are the things they're really missing. So here's the reality that every entrepreneur has to understand. Judges rule based on the 4 corners of your agreement. That's a legal term. So that's what's written inside your contract is your entire universe when you're in court. No terms equals no protection. No clarity equals risk of interpretation against you. So you have to write your contracts like the court is coming, because that's exactly how your contracts get tested, under the harsh light of legal scrutiny when money and relationships are on the line. And the key here, and this is what most lawyers miss because they want to profit off your problems, is you have to have leverage in your SOP and your agreements to squeeze your enemy to prevent court. Sadly, most entrepreneurs don't value their contract until it's too late and they desperately need it. Don't be most entrepreneurs. And just for you you can copy my client contract and you can take a deeper dive in the next video that I'm recommending, which is my special webinar I created all about toxic clients and how to use my contracts, my SOPs, my system to stop them. And you can copy all that. Just click the link below in the caption and I'll see you there. I'm the Battle Tested Lawyer. Stay legally bulletproof. I really hope that you enjoyed this video, but if you're sick of guessing whether your business is exposed to legal threats you can't see or didn't know was coming, those enemies, mistakes, and liability that cause entrepreneurs to lose, then I've got something very special for you. It's my free business risk report, the same kind of analysis I charge $7,500 for in person when I do my business defense legal mastermind. Click the link below, answer some strategic questions about your business, and get a personalized risk report. You've got nothing to lose. Find out what's hunting you and your business before it destroys everything you've built. I'm Karam, the Battle Tested Lawyer. Stay legally bulletproof, please.